I'm Jim Watkins. If you have recently received a charge of driving under the influence of alcohol, you need to contact an attorney immediately. A DUI can have a profound impact on your life. You can lose your driver's license, you could lose your job in some cases, you could lose your freedom, and you're going to find that the fines and other expenses involved are fairly significant. If you took a breath test and you had a blood alcohol level of 0.08 or above, or if you refused the test, the arresting officer probably served you with a form from the Department of Driver Services seeking to suspend or revoke your driver's license. If you receive that form, and it's generally an 8.5 by 11 yellow piece of paper, it'll have DDS 1205 somewhere on it, you need to ask for a hearing, not by phone, but in writing by certified mail to the Department of Driver Services. If you forget to do this, or if you just don't do it, there's a good likelihood you're going to lose your driver's license administratively, and this is before the DUI case even goes to court the first time. If you have received a DUI, don't automatically assume you are guilty. Contact an attorney that knows what he or she is doing. Investigate the case thoroughly. Make sure you do everything your lawyer asks you to do. Get copies of the arrest reports if you can. Get your driver history. Make copious notes, everything that you can recall about the night or the day that you got your ticket, so that you don't forget. Every little fact can make a big difference in the defense of a DUI case. The key is thorough preparation. Don't put it off. Don't wait. When you go to court, your first appearance is generally an arraignment. That's when you get to go before the court and tell them how you plead. The arraignment date is key because many motions and other things that lawyers file need to be filed by that date. After your arraignment date, if you've entered a plea of not guilty, your case will ultimately be placed on a trial calendar. If your case is in a city court where they don't have jury trials, you may transfer your case to the state court of the county where that city is located, where you will be afforded a right to a trial by jury. In some cases, that's not a good idea. In other cases, it is. Important is that you have someone that you can trust, who is knowledgeable in this area, and who can talk to you plainly and simply, and you understand what your rights are and where your case is going. If you have somebody that's knowledgeable and prepared, oftentimes you may be able to persuade the state not to prosecute your case or let you plead to a charge other than driving under the influence. This is the exception rather than the rule, but it's possible. Again, you've got to hire somebody that knows the law, knows the procedures of the various courts in which your case may be pending, and knows how to communicate your situation, your course of action, both to you and to the courts.